Hi, I'm Clay Phillips. I'm a mediator and mediator trainer, and this video's CLE entitled Mediation and Domestic Violence, the Law and Process is approved for 1 hour of CLE by the Tennessee Commission for Continuing Legal Education and Specialization. Here in Module 1, we'll discuss the purpose and scope of mediation in cases involving domestic violence. One of the main reasons that mediation exists in cases involving domestic violence is one, because there's a lawsuit between two people that either have or have had a domestic relationship. They could be spouses, they could be boyfriend, girlfriend, but the key factors is that they either live together or they currently live together. So that's one of the main qualifiers for the use of mediation in this setting. Next is the courts know that when any of us go to trial and have to go to court for anything, it just increases our anxiety and our stress level. Going to mediation has more times than not the opposite effect, and that is it's because it's private, it's a confidential setting. The people that are involved in the lawsuit aren't exposed to everything else that's going on in the courtroom or the courthouse at that time. Generally speaking, they're alone with the mediator and their attorney, so that by itself also tends to bring the anxiety level down. Next is it's a lot more expeditious of a process than going to court, so it serves the court's docket well in that these individuals or these folks that are involved in this lawsuit don't have to wait to have their issues heard by the court and have whatever it is that they're complaining about against the other person addressed. Next is going to be the matter of safety, just personal safety altogether. In the courtroom, simply because we have court officers and perhaps police officers that are present, doesn't necessarily set up the ideal venue for safety as far as either one of the parties goes, or their lawyers for that matter. At divorce or parenting mediation that involves domestic violence, because it is a private setting, the mediator has a lot more control over where the parties are located and how they are placed in relationship to the other. In other words, in domestic violence mediation, the parties will never see each other. In fact, if they're even in the same building together, they're probably not even going to know what room the other party's in. I've done some mediations, in fact, where one of the parties I had involved using Skype, FaceTime, things like that, just to help ensure the safety of not just the victim that's involved in the case, but myself and any attorneys or advocates that might be involved. Well, in all domestic violence cases, the number one precaution is safety. And one of the best ways to ensure safety is to not have the parties anywhere they can see each other, much less be in the same room together. So the advantage there is not just for the mediator to be able to discuss the issues with each one of the parties openly and freely in a very comfortable environment for them, but also keeps the parties, again, away from each other. So if one did have an outburst, then at least the other party wouldn't be present when that happened. Generally, the types of cases that are going to be mediated that involve domestic violence are going to have to do with a co-parenting issue. In other words, the people that are involved in the lawsuit are parents of a child. The parents might be divorced, they might be separated, they might still be married, they may never have been married. So generally that's going to be the most common type of case that domestic violence mediation is going to be involved in. There are other types that are not as common, that it might be in fact a civil lawsuit by nature. In other words, it might be a lawsuit that has to do with a business dealing or arrangements that are made in a business dealing, where the two of the individuals at least that are involved in this business dispute had at some time some form of domestic relationship. Something happened, the police were called, a police report was taken, and or one of the parties got an order of protection against the other to keep them at a safe distance, if nothing else, from the other. But those are the types of cases generally that can be mediated using domestic violence mediation, is where there's some sort of criminal activity between the two people that involves person against person, physical violence, sexual violence, typically one of those two areas. When it comes to the types of relationships that are generally involved in domestic violence or domestic abuse cases, generally have no regard for the gender of the parties, sexual orientation of the parties, religious beliefs or preferences of the parties. The main thing is that the two parties have a domestic relationship with one another. Does this mean that this would include roommates? I would tell you that stereotypically, if a police officer is responding to a call, they're going to see this as an assault and then make a determination if domestic violence is also one of the categories of their report. It's not to say that if both parties are male or both parties are female that the officer is not going to see this as a domestic violence episode. If they find out at sometime during the process of taking their police report that the parties are involved in a romantic relationship, it's something more than roommates, the police officer is absolutely going to add the domestic violence element to this. And those types of cases do get treated a little bit differently than, say, an assault between roommates. And the reason being is because when there's what's known as an intimate partner relationship, the different types and levels of abuse tend to go a little bit deeper. They're more pervasive and can put people in a higher level of harm or in harm's way than if it were an assault that did not involve domestic violence or a domestic relationship. The authority to mediate cases involving domestic violence are going to be found both in Tennessee law, and that's going to be generally found in Tennessee Code Annotated 364131, that's the statute number, and also in Tennessee Supreme Court Rule 31, and that's going to be found in Section 17, subsection G, that has to do with domestic violence and the requirements that the mediator must meet to earn the special designation to mediate these types of cases. Now, the statute in particular that I mentioned, 364131, provides that there are 3 requirements that must be met in order for mediation to occur when a case or a lawsuit involves domestic violence between the parties. And that is, one, that the victim or the alleged victim of the abuse cannot be forced to attend mediation. In other words, it has to be voluntary. The judge or the magistrate or whomever the judicial officer is can offer this as an opportunity for the victim to resolve this case rather than have a trial, but that victim cannot be made or forced to attend mediation. Next, the mediator must have special training in mediating these types of disputes that involve domestic violence. And third, the victim is also allowed to have an advocate of their choosing at mediation in addition to an attorney. And that advocate can be anybody from a relative to a pastor or a member of the clergy, a therapist, or their best friend. Whomever that advocate happens to be that they have at mediation, by law is not permitted to charge them anything, and anything monetary to go to mediation with them. The opportunity that this form of mediation offers is that regardless of the level or the type of dispute two people are involved in, they can reach a legally binding agreement as a resolution to whatever that dispute is and avoid going to court, sometimes altogether. They can reach an agreement through mediation and then have that agreement filed with the court, and the court accepts it. It becomes then an order of the court, which makes it fully enforceable. So both parties are bound to it, and then avoid going to court and letting the judge decide what the outcome is going to be. If there is any type of physical relationship between the two people that are involved, and something about the relationship turns abusive or even violent to that extent, mediation still can help these two folks avoid going to court, the cost that's associated with going to court, and the stress that's associated with going to court from just having to live with the ordeal and probably even the public humiliation of going to court and being in front of whomever wants to walk in the courtroom and watch. Where mediation's private and confidential, going to court isn't. In order for the case to go to mediation with a domestic violence mediator, one, the law says that there has to be domestic violence in the relationship. And as a mediator, and as well as working with the court, it's my job to help determine exactly what that domestic violence in the relationship or the history might be. The two simplest ways for me to ascertain this, particularly with people I've never met before, I don't know them, is one, is there a police report? Has one of the parties or both of the parties called the police and had a police report taken and alleging domestic abuse, domestic violence, things of that nature? Second, and it might be a situation to where the relationship is completely absent of a police report. Police have never been called. Neither of the parties ever called the police to report domestic violence against the other person or from the other person. But they might have an order of protection. One party might have an order of protection against the other person. In that setting, one of the parties may actually be using the order of protection to, or using it as leverage against the other person to get what they want, when there is, in fact, no history of domestic violence, and sometimes there's not even a threat of harm at all. It's simply a jockey for power or an attempt to leverage against the other party's bargaining ability. If there's an order of protection in place against one of the parties, that can cause a lot of harm to the respondent, the person who the order of protection is against. For one thing, it immediately suspends that person's Second Amendment rights. They can't possess, and they can't even be in the presence of a firearm. So if this person, the respondent on an order of protection is a police officer, they lose their job. They can't work at the desk because other police officers are around them and they have weapons. If they're an avid hunter, they can't hunt as long as this order of protection is in effect. If dad is an avid hunter or a police officer, then the respondent, say it's the son, is the respondent on the order of protection, then son cannot go to dad or mother and dad's house for Thanksgiving because dad has guns in the house, because dad's an avid hunter or dad's in law enforcement. That's also to state that the respondent to the order of protection can't even go to Walmart because Walmart sells guns and ammunition. So the respondent to an order of protection is living under a very, very, very intense microscope as long as that order of protection is in effect. And if the respondent ever violates that order of protection, then that becomes a criminal offense, and generally means that that respondent's going to be incarcerated Sometimes and many times, depending on the severity of it and the intent that's behind it, could be all the way up to 11 months and 29 days in the county jail. Well, as sad as it is, or sad as it may seem, there are some people out there that will use that order protection to leverage either pain or control against the other party.